We start off, we've got two cases, correct?
Correct, Your Honor. Both.
And you are Caleb Landry?
Sir.
In 23 CR 908, the earlier case, you were charged with the state jail felony of burglary of a habitation on or about February 14th, 2023.
Let's break this down. Burglary of a building might sound like a minor offense, but in Texas, it's still a felony. And a felony means real prison time, up to 2 years in state jail. This isn't a warning, and it's definitely not a slap on the wrist. It's a permanent criminal record that stays with you for life.
And that carries with it no less than 180 days up to 2 years in the state jail. You'll understand if convicted.
I think you said burglary of a habitation.
I said burglary of a building, state jail, a burglary of a building,
Yeah.
not a habitation. A burglary of a building, which is lesser than a burglary of a habitation. That's no less than 180 days up to 2 years in the state jail. Burglary of a habitation is a second degree felony. Do you understand what you're charged with here in this?
Yes.
And in 24 CR 2225, filed on October 23rd of last year, this states that on September 17th, 2024, that you committed the state jail felony of burglary of a building. It's like the same building owner. The victim is the same as the previous case.
Probably discount tires.
And it goes on to state that you have, in this indictment, you've been convicted in 2005 felony offense of illegal possession of marijuana, a state jail felony out of Harris County, Texas. And in 2015, you were finally convicted in the criminal district court here of delivery of marijuana. And that doesn't affect the punishment range on this, does it?
Yes, Judge. If he's
Two prior state jail felonies on separate.
Next to the third.
Next to the third degree.
Well, your punishment range is in two things that are problematic. Your punishment range will be enhanced if this is proven true to what would be a third degree felony punishment. It's state jail felony, but it's punished as though it was a third degree felony under law. And you were looking, therefore, at no less than 2, no more than.
Now here's where things get serious. Because he has prior felonies, the punishment just escalated. Instead of state jail, he's now facing 2 to 10 years in actual prison under third-degree felony rules. No probation, no leniency. Up to 10 years locked behind bars. A harsh reality with zero shortcuts.
10 years confinement in prison and a fine up to $10,000 can be assessed. Plus, if this is true, you are not eligible for probation in either of these cases. Do you understand?
Sure.
Okay, should be a lot on your mind here. What are we going to do today?
Your Honor, the state has tendered an offer of 12 months or 1 year in the state jail facility. And
how much time does he have credit, if any? Please. Okay, go ahead.
And Mr. Landry's advised that he's refusing that. Is that correct?
Okay. That's what you want to do?
The state's offer.
That's what you want to do?
Because
It's a hard decisions, but it's your life. Right now, we're at a crossroads. It's either going to go that way or this.
This is the moment that changes everything. A life-altering decision. Take the 12-month deal now, or risk everything by going to trial. What would you do? Roll the dice, or take the deal? Drop your answer in the comments below. We want to hear from you.
Which one?
To be clear, one thing that hasn't been stated, he is not eligible to receive probation from a jury.
I said that.
Should he do that, I will, if he continues down that path, I'll withdraw the state jail offer and give the enhancement notice on both cases, so that they're both dealing with third degree. Sure.
Okay, it wasn't. Yeah,
it wasn't included in the first indictment for some reason. We must have recovered them by the time he alleged to have committed the second offense.
He has 17 days credit.
Yeah, not a lot.
Not a lot.
Let me ask something here. What's his bond?
What are your bonds?
$5,000
each.
$5,000
Each. Yeah. Probably 5 each, Your Honor. I would have. That's what he seems to.
He's correct.
Okay. When was this bond posted? In 908. I'm looking at July 15th of 2024, correct? Is that right, everybody? That's what I'm seeing.
If that's right, then
It's $5,000
he's alleged to have committed the second offense while he was
in
on bond.
September. Yeah, we got a bond issue.
This is wild. He's accused of committing another burglary while already out on bond for 4 previous charges. The first one? That's like setting your own house on fire during a fire safety hearing. Judges don't just frown on that. They crack down hard.
Or
Interrupting the court. I didn't have anything to do.
you didn't. Yeah, you're always the first suspect, but you've been cleared in this
I would
one.
like to take credit.
Anyway,
I don't have any notes to explain, Judge.
those were being changed without, and this court had authority over this case, and somebody else was changing these.
It was post-indictment. Yeah.
It was post indictment after I had signed these orders, which are equivalent to an order, which is inappropriate, but we'll figure it out. Anyway, this court doesn't find $5,000. I mean, I put $25,000 up here, but I did this before this indictment shows up.
Right.
And then this indictment shows up, another burglary of a building, which is alleged to have occurred on or about September 17th of 2024, after he was on bond here. Your bond's $100,000 in each case. Plus, you have to have a GPS device as a condition of bond. So this is irresponsible and of your part. Once you are charged with a crime and a bond is set, and you're presumed innocent unless found guilty. But these are probable cause decisions by the grand jury that you probably committed these crimes, which are what we base bonds on, as the probability a crime has been committed. And we use the circumstances of the case and the criminal history. Your first bond of $5,000 is the same type of offense that you post a bond. A few months later, you're committing another of the same offense, the same type of offense, as though.
And boom, the judge drops a new order. $100,000 bond on each case and a mandatory GPS monitor. Why? Because this man allegedly kept committing the same crime while already facing charges. That's bold, and the courts had enough.
None of this mattered to you. You weren't taking it seriously. You are now. We're going to take it seriously. You can't just keep committing crimes and think that you can just pay a small bond and not that additional information and additional crime commission won't have a bearing on it. It does. So those are the orders. You must have a GPS device, and the bonds are amended to $100,000 each because of your criminal history and the fact that you're committing the same crime after you posted a bond in the first case of a similar matter. Just a few months after that, you're committing the same kind of crime, according to the grand jury. Anyway, that's the orders of the court. Next event, you set these for trial. It'll be set for trial. Thank you. That's what we'll do.
Okay. It's like